If you think you can file a UDRP case to get control of a domain name after failing to negotiate the acquisition, think again. That could be a terrible decision for your business. Stay tuned to find out why. I have 3 short sponsor messages before we get into today's show. First, if you have a great domain name and nothing to show when people visit, you're missing out on potential advertising revenue, leads, and partnership opportunities. NicheWebsites.com can build you a site quickly with a price option to suit any need. But as their tagline says, they don't just build websites, they build businesses. Second, if you're buying or selling a domain name or a portfolio and you want an estimate of its value, Estabot.com is the place to go. Just like you'd visit Zillow.com to get an estimate of a house value, Estabot.com provides key information about the most important statistics so you can make an informed decision based on data. Finally, DNX.com is a domain name exchange that uses a reverse auction platform to provide fair market prices for quality domain names that are manually filtered by an experienced broker. At DNX.com, domain prices drop until someone decides the price is right. But don't wait too long or the domain you love might be purchased by someone else. All 3 sponsors have a clickable banner in the upper right-hand corner of DomainSherpa.com. Here's your program. Hey everyone, my name is Michael Seiger and I'm the publisher of DomainSherpa.com, the website where you come to learn how to become a successful domain name investor and entrepreneur directly from the experts. The Uniform Dispute Resolution Policy, or UDRP, was put in place by ICANN to streamline the process to resolve disputes between trademark holders and domain name registrants. But there's been what seems like an upswell of UDRP cases filed where the trademark holder is trying to use their trademark to take control of a domain name they may not have rights to. They start with Plan A, negotiate to buy the domain name, but if that fails, they quickly resort to Plan B, use the UDRP process to take the domain name away from the registrant. Today, we're going to examine one of these cases so that businesses, the leaders of those businesses, and their attorneys representing those businesses can learn from this situation. I'd like to welcome to today's show intellectual property attorney John Berryhill. John has represented many domain name registrants and has won more UDRP cases than he can likely keep track of. John, welcome to the show.
Thank you very much. I was hoping you weren't going to ask for, a number.
I am going to ask you for a number, but first I have a warning. I want to start off saying that this interview is not legal advice. John and I are discussing a specific case, and this is general information only. If you're a domain name investor, an entrepreneur, or business owner faced with a UDRP-related issue, consult with a qualified attorney. So, John, how many cases? I am going to ask you that. Do you have it? Is it like 10? Is it 100? Is it 1,000?
Yeah, it's about 4 or 5 a month.
Wow.
Really for the last couple of years, and I've been doing this since the policy started. It started in 1999, which means the first decisions started coming out in 2000, and so I've been involved in really hundreds of cases. Some of them settle, many of them turn out well. Once in a while, you get a situation that's a difficult one, and it's sort of like being in the emergency room. You don't get to pick the condition of the patients that come in, but you do the best you can, and I think I've done pretty well.
Yeah, and we're going to be discussing a case, John, where you represented the domain name registrant, but are there cases where you will represent the trademark owner as well?
Yeah, there are a few, and actually, it's kind of funny that you mentioned that because one of the interesting things is that there is an argument that comes up because I've done so many cases that sometimes there's an argument that comes up that essentially says, well, because the respondent's being represented by John Berryhill, he must be a cyber squatter. Which is kind of a funny one given my record, but I did have an instance where someone had listed a number of cases in which I had represented people where the domain name had been transferred, and as evidence that I don't know what I'm talking about or something. I don't know. Whenever an attorney decides to attack the attorney, it's because he's pretty much lost the case and lost his mind. But he had picked out a bunch of cases where I had represented complainants successfully, and that was kind of amusing. But yes, I occasionally take complainant work, and actually I find that harder to do.
Because the burden of proof is on your lap.
Yeah. I mean, the UDRP, requires there are a couple elements that the complainant has to prove, and so they have to build a box. And on the defense side, you only need to find one hole, one way out of that box. And unfortunately, on those occasions when I do complaints, I get really locked up because I spend so much time defending these things that I think of, every single defense that can come up, and it's really actually kind of nerve-wracking. But I would say procedurally and everything else, it's easier on the complainant's side.
Yeah. So it is like a murder case where a defendant is innocent until proven guilty. So basically, the complainant needs to prove something, and you just need to. If you're representing the respondent, you just need to find a hole.
Well, I wouldn't say you're innocent until proven guilty. I mean, it's surprising how many times if a complainant makes an assertion in a complaint, this is taken as a fact by the panel. If a respondent says something, they better be able to prove it. But typically, one of the most effective weapons there is in UDRP complaints is because complainants come in, treating it like the worst crime since Pearl Harbor had occurred, and engage in a lot of hyperbole that is sometimes helpful to point out that, maybe the complainant's just a little bit too confident here and hasn't taken everything into consideration.
Yeah. How long have you been focused on IP law, including patents, copyrights, trademarks, and domain name issues?
Oh boy, since around, I guess, 1992. I had started life as an engineer, and I had a doctorate in electrical engineering and solid state materials. And I come from a long family line of engineers, and my father had asked me when I was young, just, you can be whatever you want to be, just don't grow up to be a lawyer. And I feel good about the fact that my father was deceased before I entered law school, so that promise was as good as he was around. However, what motivated me to get into intellectual property law was my interest in technology, and I found I liked talking about it a whole lot better than I liked doing it. And that I enjoyed talking about it and explaining things and working with words. So in 1992, I went to work for a law firm in Philadelphia that had been founded by a former commissioner of the U.S. Patent and Trademark Office, and worked there for. I was there for about 14 years. Started as a patent agent, which is a non-lawyer specialist who
just like Thomas Edison.
Yeah, who can represent people in the patent office. Went to law school at night. The law school I went to gave me a full scholarship. They liked my application. They said, "Why did you select us?" I said, "It's convenient to public transportation." And it reached a point where I was primarily commuting to work and going to a firm to work for my own clients, and the firm was doing traditional nuts and bolts stuff, and so I figured it would probably be better to open up my own shop, deal with domain names exclusively, and I still do consulting and take occasional work for the firm that I used to be in. So it wasn't any sort of a divorce or anything like that.
Great, John. Let me set the background before I ask you a series of questions. A client of yours tipped me off to a UDRP decision that was published in December 2013 regarding the domain name QLP.com, a three-letter domain name. The decision is published as public information. Anyone can go to wipo.int or udrpsearch.com and type in QLP.com to find it. I'll have a link below the video as well. As we know from previous Domain Sherpa interviews and Domain Sherpa reviews, three-letter domain names are highly desired and can easily command a six-figure sale price. In this WIPO case, number D 2013-1691, the complainant, or the party filing the UDRP complaint is a company named Quality Logo Products Incorporated of Aurora, Illinois. They claimed trademark infringement of a domain name registered by the respondent, the person defending the registration of the domain name, which in this case is Get on the Web Limited, a UK-based company. Quality Logo Products holds a trademark with the United States Patent and Trademark Office, filed in August of 2008, granted in April 2009 for the standard character text letters QLP, specifically for, quote, customized printing of company names and logos for promotional and advertising purposes on goods of others, end quote. Now that we've set the background, let's take a step back in time, and then we can work through the details. Prior to filing the UDRP case, do you know if Quality Logo Products contacted your client, Get on the Web Limited, to try and acquire the domain name?
Yeah, I'm pretty sure they did, and it's very rare that these sorts of disputes just erupt, completely out of the blue. Although a lot of times they won't be preceded by a cease and desist letter, but what you'll find out is someone inquired to buy a domain name, talked to you a little bit about it, maybe exchanged some email, and got a price quote, and then went away. Mm-hmm. And then a month later, you get this piece of paper that says, here's a trademark that you never heard of, and oh, by the way, here is your response to our email where they wrote to us and were trying to sell us this domain name. It is one of the most common patterns that there is. Most domain name disputes that I've seen in the last 2 or 3 years were preceded by a sales inquiry, and either were premised on that, or better yet, failed to mention it when they filed their complaint.
Yeah. So in this case, I actually got some information from the respondent. Between 2006 and 2009, Get on the Web Limited received a number of offers from Brett Bonnet, Bonnet, and Michael Wenger of Quality Logo Products. They never once claimed any rights to a trademark. The last contact from them was in 2009, and then 4 years later, they filed a UDRP in 2013.
Right.
Now, when Quality Logo Products files, or any company files a UDRP case, they need to prove a number of things in order to have a decision in their favor. What do they need to prove?
Okay, well, they need to prove 4 things. Number one, they need to prove that they can write a good check for $1,500.
Who does that check go to?
Well, it goes to WIPO.
Okay, to WIPO.
WIPO will keep 500 of it. They'll give the panelists 1,000.
Okay.
But they need to prove that the domain name is identical to or confusingly similar with a trade or service mark in which the complainant has rights.
Okay.
There's sort of 2 places where you attack there. A lot of times you find out that the person that filed the complaint actually doesn't have rights in the trademark. Some very complicated corporate organizations sometimes don't keep track of to whom their intellectual property is assigned, so that's fun. And then, of course, is the domain name identical or confusingly similar to it?
Okay, go ahead. So that's the first criteria, besides writing the check. Second criteria is...
Does the domain registrant have legitimate rights or interests in the domain name? And these are things that is the registrant using the domain name for a bona fide purpose? Is it being used for a legitimate offering of goods prior to notice of a dispute? That's sort of the types of considerations that are most relevant to domainers. There are some other exceptions for non-commercial, fair use, criticism, commentary, that kind of thing, but it's interesting to see the commercial guys get all excited about free speech cases because, typically doesn't apply to what they're doing.
And then there's a third criteria.
Yeah. The third criterion is the most interesting one. It is whether the domain name was registered and used in bad faith. And I look at that. There are 2 ways of looking at that, because you say, well, it's the third criterion, but it says registered and used in bad faith, which indicates to me and to most English speakers 2 things: registered in bad faith and used in bad faith, which has historically, and most UDRP panelists, I believe, agree with this proposition, that in order to have been registered in bad faith, the domain registrant had to have had an intent at the time that they acquired the domain name that was somehow informed or motivated by the trademark that we're talking about. That is a conscious, intent.
Mm-hmm.
And when the UDRP was first formulated by an expert panel at WIPO, they grappled for a long time over this concept of cyber squatting. And they actually decided not to try to define the word cyber squatting because that word means so many things to so many people. I mean, my personal definition of cyber squatting is that, if there's something that you want and someone else on the internet has it, then what you have is cyber squat. But anyway, what they were trying to get at was they redefined this thing and called it abusive registration, which I think is a much clearer term, really. That is, there was something in the registration of the domain name itself that was abusive, that was predatory, that was ill-motivated. And what I usually try to do is to, when a client comes to me with an issue, first question I ask is, well, why did you register this domain name? And that's really what the UDRP is about. Why did you register this domain name? Did you register this domain name to rip somebody off? Did you register this domain name because, you thought it was a catchy phrase? Did you register it because it's a generic word that has a large market and lots of potential value? That is sort of the first step toward defending a UDRP case, is getting a clear handle on, why did this person register this domain name? And if it wasn't motivated by the trademark, then you like to think they ought to win. Unfortunately, many times you'll have someone that registers a domain name, throws it on pay-per-click, doesn't care what comes up, and then you have, a word like, United, which could be used for all kinds of things, selling airline tickets. Well, United is a great word. It's used all over the place. But if it's being used to sell airline tickets, then it gets really hard for the domain registrant to say, well, no, I really didn't mean that. See, there's this parking system and Google Ads and all this other. UDRP panelists don't understand any of that. They can type a name into a browser, see what's on the page, and then make guesses about what your likely motivation was, regardless of what your motivation may have actually been.
All right, so let's go through those three criteria. They need to prove it's identical or confusingly similar. They had a registered trademark for QLP. The domain name is QLP.com. So it seems like that was a match.
I can't remember, and I want to try and bring something up on the screen here. I can't remember. Can I do that?
Yeah, you can share your screen and then turn off the share screen. Let's see if this works.
Okay. I don't remember the exact set of trademark claims that they had made, but they included in there things that looked like this.
Right. So this is the United States Patent and Trademark Office website.
Right. And let's see. I need to scroll down. This is one of their marks. And what was really crazy about it is that you can't even see. It's this cartoon character with a T-shirt on, and apparently, and I can't even see. I'm going to try and make this even bigger.
So this is actually what was submitted by the attorney representing the Quality Logo Products Incorporated company. They had two USPTO trademarks. One was the actual character mark, and then one was this one that you're showing on your screen, which is just some sort of iconic guy. I don't even see a QLP. Maybe it's on his shirt.
Yeah, you have to kind of take it on faith that it's on his shirt. Now, and like I said, okay, is that stopped now?
Yeah, no, I still see it. But I can only assume that this was an error.
Well, no, actually, what they'll sometimes do is they'll throw in, sort of everything in the kitchen sink. And that actually makes it hard for panelists. If you have a trademark, and this is the easy part of the UDRP. This part is actually easier than writing the $1,500 check, and it's surprising how many people get it wrong. State your claim, present your evidence, get off the stage. And most panelists treat this as just sort of a standing requirement if you have a trademark of any kind. But a lot of people will show up with these sorts of, logos or graphical marks, which will sometimes, that guy could have been wearing a shirt that said printing on it, right? The word printing.
Right.
And the word mark part of the record here, the word mark part of the record here would say printing, right? And then they'll show a database printout and says, oh, we have a trademark in printing. Unfortunately, some panelists will say, well, because the graphical part of these types of trademarks can't be reproduced in a domain name, then we'll just ignore all that. We'll ignore the fact that if somebody looks at this trademark on a product, they're primarily going to see, some yellow smiley face dude. And, just ignore the commercial impression. But in any event, yes, they have a trademark. This trademark post-dates registration of the domain name by about 10 years or so. I believe these trademarks were, filed for in something like 2008 or something like that.
Yes.
But the first criterion, and it's interesting, in the early days, they used to just say, well, the first criterion is that they have a trademark that's identical or confusingly similar to the domain name. And but we think it's somewhat implicit, because where we're going is, why did the guy register the domain name? We think it's somewhat implicit that if somebody presents a trademark, it should predate registration of the domain name. But that was pretty much taken for given for the first 2 or 3 years. And then they started saying, well, it doesn't say that in the first criterion, it doesn't say that the trademark has to predate the domain name. So we'll tell you what we're going to do. We'll say, if they have a trademark, we don't care what it was for, we don't care what it looked like, we don't care when it was. Okay, they have a trademark, let's go to the next step.
Right. Then the next step is the respondent's business is related to the domain name in some sort of way. And in this case, Quality Logo Products was saying the respondent's business is unrelated to the domain name, and the respondent's business is in the business of buying and selling domain names, and they offered this domain name for sale at $125,000. So they said that the business of the respondent, the client that you were representing, was buying and selling domain names, and they offered to sell it at $125,000.
Yeah, and typically, because the criterion for them is to prove that the registrant has no legitimate rights or interests.
Right.
A lot of times they'll just say, the registrant has no legitimate interests because it's identical to our trademark. They don't really, it's the most amazing thing.
But that's not really a defense, right?
You could have all kinds of things going on at the website, and complainants will just ignore it. All right. And in this instance, I think that briefly the name had gone to PPC use, but the criterion is, did the respondent engage in a bona fide offering of goods or services prior to the notice of a dispute? Now, you can say, okay, well, I filed this dispute and the website's not doing much of anything. But reading the literal language says, well, what were they doing for the last 10 years? What were they doing for the last, 5 years with the domain name? Is there anything in the history of their use of the domain name that indicates, a purpose? But in this, and the sales stuff kind of comes in later, but typically if they've had some kind of, sales inquiry or something like that, and it could be the domain name, one of my favorite cases was decal.com, decal.com. It was a pay-per-click parking site that you would never believe what was being advertised on that website. Shockingly, the respondent had been advertising decals at decal.com. And because an oil container manufacturer for shipping terminals in Spain was known as Decal, obviously everyone in the world knows this. But what they'll do is they'll just say the domain name's not being used. No matter what's there, they'll say
Right.
if it's a parking page, they'll say it's not being used. Never mind the fact that there are people that earn quite a bit of money from this. It just doesn't exist.
So they need to prove rights or legitimate business interest, and a right is like a trademark or a service mark. Is that like what a right is?
It can be, but it doesn't have to be. And because it lists a grab bag of things like offering of a bona fide services, demonstrable preparations to use the domain name, these are all just sort of, expectation and reliance interests, equitable interests in being able to do what you want. But yeah, the first thing out of the box is they'll say, oh, well, the respondent doesn't have a trademark. Well, you don't need a trademark to do, I didn't need a trademark to name your kid. You don't need a trademark to, to go do things. It's nice to have them for certain purposes.
Yeah.
But the best example of that I ever saw was a case recently where I was defending the domain name, and this is really hard to believe, the domain name businessforsale.com.
How much more generic could you be than businessforsale.com?
You'd never believe what was going on at that website, Mike. There was a complainant in the United Kingdom who operates businessesforsale.com, and they said, we have common law trademarks in businessesforsale.com. And this guy has businessforsale.com, and he has no rights in it. And the first thing out of the box, they say, he doesn't have a registered trademark for it. Which was a really interesting allegation for them to make, because not only did the complainant not have one, but they had filed for one in the UK and it had been refused. And they didn't mention this fact, but it boggles the mind sometimes how hypocritical people can be. Say, oh, well, we have all these common law rights and he has no registered trademark. Never mind the fact that we don't have one because nobody's going to get a trademark. No one's going to get exclusive rights in the phrase businessesforsale.com.
Yeah.
But they argue this stuff with a straight face. And so, you said, well, you made it sound as if the respondent then has to prove they have legitimate rights or interests. Well, quite frankly, it's up to the complainant to prove you have a lack of legitimate rights and interests. Unfortunately, because of the problem of trying to prove a negative, they make it seem as if it's up to you to prove you have a legitimate right. And so there's been this battle, and the UDRP is determined. These decisions are determined by a roster of individuals who, have ideas of their own and fall into certain camps. And there is one school of UDRP panelists that say, well, pay-per-click targeting of domain names is not a legitimate interest in the domain name. I mean, they're not providing any content. They just have a search box and you do searches and they send you to other content, right? And I always find that really interesting because I really hope that Google never gets into one of these things because, what some people consider to be the most valuable website in the world, the most, dynamic, largest internet business in the world, their website is a search box with a button.
It's not a legitimate business.
It's not a legitimate business. They just send you to other sites,
right.
So it's a legitimate business for Google and Yahoo. It's not a legitimate business for anybody else. That's always difficult to understand. So, I typically conclude that section in a defense by saying, the complainant has failed to prove this is not legitimate. And it is interesting how, on balance, what the panelists will do, because they don't want to spend all this time fighting among themselves, is they'll say, well, we're going to pass on this issue because they'll say, because because of our finding under bad faith, where they find in favor of the respondent, we're not going to really, take a position on this. And it is kind of funny because they're not being asked to say whether or not pay-per-click parking is a legitimate use. They're just being asked, did the complainant prove it was illegitimate? But they've turned it around and made it and did make this section, sort of what you said, which is where you have to prove your legitimate rights and interests. But and of course, I do that every time, but it really bothers me. I don't like the fact of people being accused of things and then having to prove their innocence.
Right,
that
or the complainant
really
not actually proving anything, but because the panel doesn't review only half of the story, you need to then get whatever you're going to get into the response before the panel reviews it, which requires you then to defend something without even the complainant proving anything.
Oh, yeah, and sometimes you have to, I mean, the worst ones of all are where the complainant's argument is just so bad, but the complainant could have made a better argument. And you're worried because you're looking at these facts and you're saying, all right, well, their argument is just, idiotic. But these panelists sometimes just can't help themselves. They'll look at the facts and they'll make a better argument, for the complainant, right? So in order to avoid that, and this is something that just drives me nuts. In order to avoid that, sometimes you have to make a better argument than the complainant did for their own side, so that you have an argument that's even worthy of knocking down, and sometimes
and then knock it down.
Yeah, and I'll say, I hate to have to do this, but let me give the complainant a better argument, and then we'll deal with that one, because I can't even figure out what he's trying to say.
All right, so the third criteria is that the respondent registered the domain name in bad faith and is using it in bad faith. And
that's correct.
How can a complainant, how did, in this case of Quality Logo Products, prove that your client, the respondent, Get on the Web Limited, registered it in bad faith?
Okay,
when it was registered before this company registered their trademark.
Yeah, it's a great question. What they do is they typically tend to ignore a lot of the qualifying language, and there is in the UDRP some examples of kinds of things that would constitute bad faith. And one of those things that they include as a non-limiting example is you have registered the domain name primarily for the purpose of selling it to the complainant or a competitor of the complainant for a price that's higher than your out-of-pocket cost or something like that. All right? And so they'll say, well, the guy tried to sell it to us. All right? And say that then satisfies that point, and totally ignoring that it says registered primarily for the purpose of selling it to the competitor. Now you can say, well, you can't read people's minds. How do you know what their purpose was? Well, I think it's safe to assume that when someone registers a domain name in 1998, they're not doing it for the purpose of ripping off someone who won't have a trademark until 2008. All right, but unfortunately, and this is really in the last 3 years or so, there are a couple of panelists that feel like, oh, well, these domain registrants are getting away with something. And what do you do about where someone has a domain name, and they can have a domain name since 1998, and someone else comes along, starts a product, gets a trademark, and then use of the domain name changes to then, be predatory relative to their trademark. And, I would agree that's a bad thing for someone to do that. I would agree it's a bad thing for a domain name registrant to abuse animals. I would believe it's a bad thing for a domain name registrant to engage in murder and rape and mayhem. All right, but this policy wasn't really designed to deal with rape, murder, mayhem, abusive animals.
Right.
It wasn't even designed to deal with trademark infringement. And it's gotten away from the idea of, well, look, we'll charge somebody a low fee, we'll get a couple of papers in, we'll take a month, we'll look at it, and if it's a no-brainer, we'll decide it. Because there are people out there registering, Microsoft something or other.com. There are people registering Xerox, this and that, famous marks that and in many cases, totally made up words like Verizon or Xerox or things like that. That everybody knows they're trademarks. Everybody knows that you're not going to be up to any good registering famous trademarks unless you're running a website that is exclusively devoted to the sale or service or parts of those kinds of things. or selling them in some way. I mean, obviously, a grocery store can use Coca-Cola and they can put Coca-Cola in their window because you go inside and there's Coca-Cola there. Likewise at your website, if you're selling, Coca-Cola collectibles, you can say this is where we sell Coca-Cola collectibles.
Right.
You have to be, you can't just say, oh, the brown fizzy soda, because it gets a little stupid. But those situations are pretty readily distinguishable. But there are some panelists who feel like, well, I'm not really comfortable with some aspect of what's going on here, and so they've made this imaginary jurisprudence around the fact, well, what about when you renew a domain name? Is that a new registration? What about if a domain name is transferred, between two people? What if I buy a domain name from you? Then if the domain name was registered in 1998, well, do we look at your motivation for registering the domain in 1998 or my motivation for buying it from you? Now, in changes of ownership situations, it kind of makes sense that you might want to look at, well, maybe the later purchaser is buying it because of that trademark that came along. And so then we're going to have to look at what they're using it for and what they're doing. But
that wasn't the case here. It was registered in 1999, I think, and the trademark didn't come into existence until 2008. One of the ways that the complainant tried to prove bad faith in the case, there's this quote: "The complainant has attempted to settle the present issue with the respondent directly and has reached out to the respondent on several occasions to purchase the disputed domain name for a reasonable price. However, the respondent has been unwilling to accept a reasonable purchase price," end quote. And then in your response, John, this is one of my favorite paragraphs that you likely helped craft. Quote, "The complainant wants the panel to decide that the respondent has an obligation to accept the complainant's $19,500 US offer. Presumably, the panel is supposed to act as a price arbitration board and determine that bad faith registration and use does not exist at any price up to $19,500, but that a penny more renders the disputed domain name to have been registered and used in bad faith. This is, however, an abuse of the policy as a negotiating tactic, which UDRP panels have seen and addressed many times before."
Yeah.
Do you have fun when you write your responses?
Lots. Lots.
Because it sounds like it's tongue in cheek. You're clearly stating the issue, and I can read sort of the disgust that the argument has to be made with, because the complainant just makes a ridiculous argument.
Yeah. And what's funny is that passage about, the UDRP is not a price arbitration board, because we've had people say, and the thing is, it's one thing to offer to settle a claim. It's one thing to say, I have a trademark, you have a domain name, I think we have a legal right here, but we're willing to settle it at such and such an amount. Okay, that's a settlement discussion.
Right.
But they typically don't come in and do that. They typically come in and just say, is it for sale? And you say, well, yeah. And they're like, well, how much? And then you give them a price. And then they file their complaint with your email as the starting point. It's just an email from you saying, I'd sell it for this amount. They don't even say that they came along and asked you for a price, okay? Because obviously you've been sitting there for 15 years waiting for them to waltz in through your door. But that particular passage I keep in a little, handy copy and paste, unit, because I used it like 10 times last year. and it has, I don't know if it's an indication of the robustness of the secondary market in domains, but this is the primary pattern. They try to buy a domain name, they go away, and then they come back with a UDRP complaint. And what's interesting is that when I said, primarily for the purpose of selling it to the complainant or a competitor for out-of-pocket costs, if they come in and offering $5,000 and you counter with $10,000, and we're talking about a domain name that was picked up at Snap Names for $69 or hand registered at Enom for $12, well, we're all negotiating over that amount. When they come in and offer $5,000 as just an offer to purchase a name without a trademark claim, no reservation, this is not a settlement offer. I think at that level we're starting to, and you come back with 15,000 or 100,000. I mean, at what point do we say, oh well, 5,000 was reasonable and 15 wasn't? And the other thing is this: a lot of these UDRP complaints are typically either the first time the trademark attorney has ever done a UDRP complaint, and so they will reinvent the same stupid arguments that have been used 100 times before. Or they're used to doing pushover cases for famous marks and they actually never deal with a case that is responded to. It's like 60% of these cases are default cases. And so they sometimes don't really realize how ridiculous their copy and paste arguments sound, as applied to a different set of circumstances. And then we come to the fact that the respondent has the opportunity to choose a 3-member panel in order to proceed. And when you do that, you send in 3 names, and one of those guys is going to be, or women is going to be the panelist. And then the other side sends in 3 names. They don't know these people from a hole in the ground, so they just pick 3 names at random. Then the center gives you 5 names, and you jointly rank them, and then it's chosen. So what this boils down to is that most of the time, 2 out of 3 of these panelists, I've done hundreds of these cases, most of the time, every single panelist seated on that panel has seen one of my arguments before, and I've seen several of their decisions before. So if we get into this round of, sort of supplemental filings that people can't resist, I can then start tailoring what I'm saying to, essentially, I know this panelist has seen 10 cases like this before, and I can just say, well, here we are again. And these people are making the same arguments. And I know that the complainant's attorney is getting paid a couple of grand to do this. I'm getting paid a couple of grand to do this. As a co-panelist in the UDRP, you're getting paid $750 to do this. Now, how many times do you want to see the same stupidity over and over again before you put your foot down and say, you know what, maybe before my valuable time is wasted for $750 where I got to spend 5 hours wading through this kind of thing at my rate, we should do something to try to discourage these people from doing these stupid things. And that's and that's why last year was a record year for findings of abuse of the policy. I can't remember the exact numbers. Nat Cohen has them on his great blog, Domain Arts. You will hear again from WIPO sometime in the next few weeks that, it was a bumper crop year for UDRP disputes. You will not hear from them that it was a bumper crop year for findings of abuse by complainants, because as I said, complainants have just gotten lazy, and I think that some of the crops of fresh young faces coming out of law school have gotten this notion in sort of the tail end of how this gets tacked in on their trademarks course that, by the way, if you have a trademark claim, you can get a domain name. Another aspect of this case, if you don't mind, was that there's some confusion among people that aren't familiar with domain names about ways to determine how long someone has had a domain name. In this complaint, the complainant had looked at archive.org, and they saw that the domain name had been used for a directory of health clubs in Britain up to a certain amount of time, and then the use had changed to parking and something else after that. And they assumed that for some reason the domain name had been registered where the use changed.
Right.
When in fact, actually, the guys who run Get on the Web had back in the late '90s had this plan where they were doing regional directories of spas, health clubs, fitness facilities in different towns in England, and they did a bunch of acronyms like. The Burton and Trent Leisure Guide. This was Quality Leisure in Poole, Poole, which is a town in England apparently, and a number of these. And the complainant seemed to know what it was being used for, but for some reason said, and incorrectly, that the domain name had only been registered since 2005 for
Yeah.
that were just never answered.
Yeah. And one of the panel actually in their response to this case wrote, quote, "The fact that a respondent is offering the disputed domain name for sale cannot as such be deemed to indicate that the disputed domain name was registered or is being used in bad faith. This is particularly the case when negotiations for the sale of a domain name have been initiated by the complainant.
Right.
Neither is there any evidence that the respondent otherwise has registered or used the disputed domain name in bad faith." So your client, didn't register it and use it in bad faith, that the complainant proved, and they didn't reach out to the complainant and say, "Hey, would you like to buy this domain name that matches a trademark that you own?"
Right. And this is, one of the things that the domain registrants need to look out for is, I'll occasionally get emails from people say, "Oh, I got an offer to purchase a domain name, but there might be a trademark problem. Can you take a look at it?" I'm like, "Well, let me see this offer you got." And they've got an email from a law firm that says, "Is this domain name for sale?" And that's when you're getting an email from a trademark attorney asking you if a domain name is for sale, you have not received an offer to sell a domain name. An offer to buy a domain name is, "Hey, I'd like to buy that domain name for $10,000. That's an offer, because if you say yes, you now have a contract. But there are these sort of offer-like objects. How might I go about acquiring the domain name? I always love that one. We would like to have the domain name transferred to our use. How do we do that? And people will write back and say, "Oh, yeah, well, it's for sale for $10,000. And they'll go, "Oh, it's for sale. Oh my goodness. No, we just thought you'd, give it to us because, my God, who doesn't, respond to random emails from people?" I've gotten, tens of millions of dollars from widows in Nigeria, and that money's coming in any day now. So I don't care what people do with the domains anymore. I've got my Nigeria money coming. But you got to treat these with suspicion. It's really good to know who's inquiring. Why might they be inquiring? Is this a domain name I haven't looked at for a while? What's the domain name doing? Has the pay-per-click, if the domain name is like, coffeecups.com, and I go there, do I see links to coffee and coffee cups, coffee making, or do I see shoes? And if I see shoes, why am I seeing shoes? Is it because someone came along and branded some kind of shoes, coffee cups, and now it's showing up in the PPC feed? And if it is, can I, get that out of there and make sure it's still coffee? Because they'll use, the junior parties will use that sort of drift to argue that you've changed the use. And there are a couple of UDRP panelists that don't understand how this stuff works that will argue it. So when you get a domain name inquiry, step one, just take a step back. What's that domain name doing? What does it look like? Is it doing what it's supposed to be doing? Who are these people writing to me? Are they writing to me, from the UK? And if they're writing to me from the UK and I'm curious about trademarks, then going to the USPTO is not really a good idea. You might want to go take a look at the UK trademark. You might want to do a Google search, find out if someone is, uniquely associated with this term, just to get an idea of, is there someone that I never heard of that's going to, just pop up out of the woodwork? And you should, on a regular basis with your top earning, most valuable, or top performing domain names, take a walk through, make sure they're doing what they should be. If you see anything funny going on, fix it. Make sure these names are doing what you intend them to be doing. It can't be done with accuracy in all cases. And someone down the line is going to use what I just said as some statement, to the effect that, well, this is what they should be doing, But good luck doing that when you have 10,000 domain names, right?
Hey, John, when you filed this response to the UDRP case related to QLP.com, how confident were you that your client would prevail?
I work on these. I don't work on these alone. I work on these in partnership with my wife, who also went to law school with me, and she finished 4th in the class, and I finished 6th in the class. And I figured, well, I don't want to ever have to argue with her, so I married her.
How's that worked out for you?
I don't know, but. she had done a joint doctorate program in psychology, and she gets into what is the complainant thinking? What do we know about how the complainant is thinking, and how can we push their buttons, and what the panelists are thinking, and so forth. And there are people who will not work with me because I will tell you you're going to lose right up to the day we get a decision saying we win. But I sometimes feel pretty good. I feel, I will typically take a case, say, oh, this looks kind of good, get into the facts and say, well, the facts are maybe a little bit messier than they looked to begin with. By the time I'm done the response, I've pretty much convinced myself that we should win. But I think any attorney that can't tell you, a couple of reasons why you could possibly lose that slam dunk case is just not being all that straight with you. But sometimes I am surprised. Let's put it this way: I've taken facts that were ugly sets of facts, thought it could go either way, and not prevailed, and thought, well, it could go either way. I have not had too many where I've looked at it and thought, well, there's absolutely no way you should lose this case, and have lost the case. Yeah. I think there's, in 10 years, there's maybe been been one or two of those, but in this one, I was fairly confident. Where you have 10 years of registration before a hint of a trademark claim, and you have demonstrably false statements made in the complaint, you're in pretty good shape.
Yeah. So it was actually 4 years between the last negotiation interaction of quality logo products and Get on the Web, and then filing for the UDRP. Yeah. What is latches, and how can that? And is this a case of latches since it was 4 years?
Okay, that's a great question. Okay, latches is what's called an equitable defense. It used to be in sort of the Middle Ages. I always wondered why lawyers always started off in medieval England, and it's like, oh God, now I'm doing it. But anyway, it used to be that in Middle Ages there were these very mechanical rules applied to legal disputes, and the king would administer those laws, the king and his agents. And the church had a different view and thought, well, sometimes there's a certain amount of fairness. Latches is what's called an equitable defense. It is a defense to certain types of claims that says, well, you have not done anything about this claim for so long that you've lost the right to exercise it. In criminal law, for example, we have statutes of limitations. In other areas of law, there's this defense of latches where, somebody has done something so long, they've been walking across your backyard, along this path that they've done for so long now that they might as well have an easement, and that it would be unfair for you to interfere with their expectations. So latches is a defense that says, if you have not asserted your claim in a certain amount of time, you lose your claim. Whether or not this applies as a defense to UDRP claims is a very interesting and long topic. In a case where someone has asserted rights against you and then done or had reason to know you were doing what you were doing and then done nothing for at least 5 or 6 years, I'll put it at that. My opinion is they've given it up. They cannot credibly claim that they just found out about this and that they're acting diligently. Now, a lot of panelists don't like this, and so there's sort of a way to make the same argument, which is what I just said, which is that, well, if they're claiming that this is causing damage to their business, how seriously can you take them since they've known about this for 6 years and done nothing? So you're better off in the UDRP context because of the disputed idea of whether or not this defense is available. Needless to say, there's 20 different flavors of things you could be accused of, but whenever someone comes up with a defense, they're like, can we really accept this? But in any event, you're better off arguing it from the perspective of, this is just not a credible claim. They've known about it for 6 years. They've done nothing. And now they're coming in here acting as if there's some kind of an emergency. There's no reason for this.
In your opinion, John, why wasn't this case labeled by the WIPO panel as a case of reverse domain name hijacking?
I don't know. I don't know. There's been some speculation on the blogs, and let me just put it to you this way. Respondents cannot choose to file UDRPs, and believe it or not, that's more frustrating than you think. Because sometimes, I get into an argument with somebody who just like an Energizer bunny, and there's no point arguing these things in emails and letters. Someone will send a client a cease and desist letter. I'll say, you got a nutty claim, go away, and they'll come back and they'll argue with me some more, and I'll just say, look, you want to argue about this? Is this a hobby of yours? Is this a profession? You're getting paid not to agree with me, and I'm getting paid not to agree with you. All right, and as long as we continue not to agree, then we're both doing our jobs, but we're just basically jerking off here. So why don't you go file a UDRP, because I can't do it, and I
Right.
wish they would file a UDRP.
Yeah.
Now the complainant gets to pick. Does he file it at NAF? Does he file it at WIPO? Does he file it at the ADNDRC? And people have different preferences based on their experiences.
Sure.
And so they're the customers. Without complainants, there are no UDRPs. All right. Now, how often do you say, all right, well, yeah, I know you came in here, you spent money, you did everything you were supposed to do. Thank you very much. And by the way, you're a jerk. Nobody likes to do that. And I've had panelists explain this to me, that the most dangerous guy in the room when you're doing any kind of private mediation or arbitration, the most dangerous guy in the room is the guy that's going to lose. So that is why you'll see a lot of decisions that basically say, the complainant came in and had this really nice stuff, and they just missed it by that much, and we agree. The respondent seems like a real slimy asshole of a jerk, no good domain person, but he just barely won it by that much, so that, I've got tons, I'm the world's most sore winner. But on the reverse domain hijacking thing, the other aspect of it is that most of these UDRP panelists, particularly at WIPO, are themselves practicing trademark attorneys. I will tell you that there are maybe 10 or 15 attorneys on this planet who I trust working for domain registrants and working for the domain community. All right. Most of the money, most of the easy work is on the other side, working for big brands and whatnot, and that's the ranks from which UDRP panelists are drawn. So if you do 20 UDRP complaints a year for your trademark clients, and then you might sit on one or two UDRP panels, how many new defenses to a UDRP complaint are you going to say are okay? How many complainants are you going to beat over the head for not behaving well, knowing that you're sitting on this panel issuing principles that might be used against you?
Yeah. All right. You've made a lot of points on why
may be valid,
why the panelists may not make a point of it. Let me ask you this: can the respondent who wins a UDRP case somehow exact some satisfaction by filing a court case to try and win legal fees, or some other way try to deter businesses from spurious UDRP claims?
Yeah, it can be done. It can be done. It has been done sometimes. And what a lot of UDRP panelists didn't know until recently was that sometimes when there is a finding of abusive process, it's not necessary to go to court to do that, because now you're the guy writing the nasty letter with the claim that says, basically, look, you put us through this, you cost us this. Let's settle this before we go to court. That sometimes happens, but yeah, you can go to court. The U.S. law does have a specific provision that allows you to recover the costs and fees of the UDRP. Unfortunately, it's actually more expensive to go to court and prove that. But there have been judgments. There was a judgment out of a Texas court in a case involving the city of Paris that awarded $100,000 damages, the same types of damages that you get in an ACPA claim on the trademark end, plus attorney's fees. So it happens. You do have recourse, but one of the things that I try to tell people, particularly when they upon their first exposure to domain disputes, is a lot of business people get really fascinated by this stuff. They get really interested in this stuff, and you have somebody who was living their life, running a business, making money, and now they're consumed with making a point. Okay. Any business has legal risks. I have a neighbor. He runs a grocery store. He's got security camera footage of people that walk down an aisle, bump into a jar of mayonnaise, it falls on the floor. The friend that got out of their car walks down the aisle, slips on the mayonnaise, hurts themselves, and these, it just comes with the territory. Every type of business attracts its own, nonsensical legal nuisances. So, some of what you hear on the domain blogs about, it's the end of civilization because people can bring legal claims. Welcome to the real world. Defending yourself in a lawsuit, and this has always been true of any kind of lawsuits, defending yourself in a lawsuit is an opportunity to spend money to do what you were doing yesterday for free. That's the way it is, and that law hasn't been changed.
Yeah.
If you want to avoid it, stay in bed, don't run a business, don't make money, don't get it. I always tell people, they're like, well, how can I, people call me up with these general questions, how can I best arrange my business so I don't get into any kind of legal trouble? And I tell them, hey, don't get out of bed.
Go work for somebody else.
Yeah, just,
Yeah.
if you want your lawyer to give you business advice, trust me, you'll never do a damn thing.
Hey, John, I've noticed, I was interested to find out what happened after this case and how the respondent is using the domain name QLP. So I went to the website QLP.com, and on it, I see a summary of facts of this case, calling out the names of Quality Logo Products, its principals, the law firm representing Quality Logo Products in the U.S., in the UDRP case, and its principals. Why is that not, defamation, slander, libel, or the host of other legal, terms that people banter around?
I don't know. I that's funny. I don't, and I probably should do it more often. Go back and look to see what happened to some of the domains. I have no idea what's going on there. Obviously, if someone wants to use a domain name that's been in a dispute to state true facts in relation to the dispute, well, that's certainly a use of the domain name that relates to that domain name. So I specifically, I have no idea what's going on there.
So it's not against the law to state public information of a stated case.
It's still legal to tell the truth. We're working on it.
All right. So unless a complainant can prove that an exact or confusingly similar domain name to a trademark is being used by someone without any rights or without any legitimate business interests and was registered with bad faith, they're likely not going to win a UDRP case.
That's right. Yeah, because it was meant to get at no-brainer cases where someone's obviously doing something bad. Yeah. It really shouldn't take an attorney. I would love to quit doing this. If everybody was doing their job, then I wouldn't have. Believe me, I have other things to do. I wouldn't have to engage in these ridiculous arguments over a policy that was meant to be, hey, if somebody is an obvious jackass, let's take his domain name away from him. It's really not. They should have just written it that way.
Yeah.
And it would have made life a lot simpler.
Well, lawyers don't typically write in those terms. In summary, for companies looking to use the UDRP as their plan B, quote unquote, to get control of a domain name after a failed purchase negotiation, in the case possible when they, they could be labeled a reverse domain name hijacker. They can lose and spend legal fees. They can end up back in court. And, in some cases that has been the case, as you've stated. So think about all those things and think about who's representing you and the criteria that you need to prove when you're filing a complaint. That's the takeaway that I got from today's show with you, John.
Yep.
If
Tell
you're
the truth.
Tell the truth. If you
Tell the
have
truth.
additional questions about this specific case, please post them in the comment section below, and I'll ask John to come back and answer as many as he can. He cannot, of course, provide specific legal advice related to your situation or to a different domain name. John, if someone wants to hire you to review their case, to talk about issues that they've been having with their domain names, what's the best way that they can reach you?
Send me an email, call me on the phone. I get a lot of, vague inquiries. If someone wants to contact me and discuss an issue, they can send an email stating that, but identify yourself. I get some really strange ones,
Oh, I bet.
but because people, are kind of like, they don't want to identify themselves, or for various reasons. They come from cultures where, that's not, sort of what you do. But I would say that, if you are making a communication seeking legal advice and, you get a response from an attorney, even without money changing hands, that is a confidential and private. It's like walking into the confessional, with the difference being it only works if I know who you are.
All right. And they can get your contact information on your website, johnberryhill.com.
That's the only thing that's there. Yes.
All right.
Yes. Unfortunately,
It serves its purpose, John.
yeah, exactly. Yeah, unfortunately, I am not. I do not have as high opinion of myself as many of my colleagues in the field. So you will not go to that website and find out, how wonderful I am, how I never lose any cases, how I'm just the best thing since sliced bread. But if you know who I am and what I do, I don't do job interviews on the phone. If you know who I am and what I do, feel free to send me an email, give me a call.
All right. And this is the point in the conversation where I ask the audience to take action. Please take a moment and post a comment to say thank you to John for his time and for sharing his legal advice about this specific case. John Berryhill, intellectual property and domain name attorney, thank you for coming on the Domain Sherpa Show, explaining this specific UDRP case and the UDRP process. And thanks for being a domain Sherpa for others.
Well, thank you for having me. It's been a joy.
Thank you all for watching. We'll see you next time.